Start. This writ petition under Article 227 of the Constitution of India is directed against the interlocutory order dated 23rd March, 2015, whereby the application under Order 1, Rule 10 CPC filed by the petitioner plaintiff for adding the parties has been rejected. Full stop. Para. Learned counsel for the petitioner submits that the trial court has committed grave illegality or jurisdictional error while rejecting the application. Full stop. It is contended that the plaintiff and defendants are real brother. Full stop. Plaintiff has filed a suit for the relief inter alia, contending that he be declared 1/4 owner of the suit property and for permanent injunction against the defendants not to deal with the suit property without seeking partition thereon. Full stop. In response thereto, defendants have filed written statement and raised an objection that the family tree explained by the plaintiff is not factually correct, as late Brijlal did not have only 4 sons, but also have 3 daughters. Full stop. As 3 daughters have not been made parties, the suit suffers from the vice of non-joinder of necessary party, and in absence thereof, no relief of the nature claimed in the suit can be granted. Full stop. On such objection being raised, plaintiff filed an application under Order 1, Rule 10 CPC for adding sisters as parties to the suit. Full stop. Therefore, it is submitted that the application was bona fide, and as a matter of fact, on an objection being raised by the defendants, the said application was filed. Full stop. Even otherwise, the application was necessary, as looking to the nature of relief in absence of other heirs, plaintiff would have suffered dismissal of the suit for non-joinder of necessary parties. Full stop. Therefore, the trial court ought to have allowed the amendment to do complete justice amongst the parties. Full stop. It is submitted that the reasons and justifications given by the trial court that despite knowledge of sisters being also heirs of late Brijlal, plaintiff had chosen not to add them as parties, and since trial has commenced, there was no justification for allowing the aforesaid application, cannot be sustained in the eyes of law. Full stop. Therefore, it is prayed that the order be set aside and petitioner plaintiff be permitted to add the remaining legal representatives of late Brijlal in the suit. Full stop. Para. Per contra, learned counsel for the respondents, defendants, though at the first instance opposed the petition and submitted that the trial court has not committed any error of law or jurisdictional error while rejecting the application, as the petitioner plaintiff had full knowledge about the sisters and, therefore, in all fairness ought to have added them as parties at the time of filing of the suit. Full stop. It is submitted that the aforesaid application has been filed only to delay the trial. Full stop. Para. At this stage, both the parties have shown their grace that this writ petition may be disposed of with a direction to the trial court to permit the plaintiff to add the proposed defendants, that is 3 sisters of plaintiff and daughters of late Brijlal, as defendants, and the trial court may be directed to decide the suit at an early date. Full stop. It is submitted, as a matter of fact, fro early disposal of the suit, this court has already ordered on 3/12/2014 while deciding the writ petition number 7446/2014 full stop para. In view of the aforesaid consensus between the parties, the impugned order is set aside and this writ petition is disposed of with a direction that both the parties shall appear before the trial court on 25th June, 2015, and the trial court shall decide fresh application under Order 1 Rule 10 CPC in the light of the aforesaid consensus between the parties full stop over.